Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations related to steno. Get ready for the dictation for Supreme Court exam. Without any stop, be ready. The Supreme Court today, February 24, overturned the acquittal of a man accused of murdering his wife, ruling that his 7-year-old daughter's testimony was credible. The court found the accused guilty based on circumstantial evidence and held that his failure to explain the circumstances of his wife's death, which occurred within the four walls of his house with only their daughter present, was a relevant circumstance as per Section 106 of the Evidence Act. Heavily relying on the child witness testimony, the court observed that the testimony of a child witness cannot be dismissed outright because under Section 118 of the Evidence Act, a child is competent to testify if they can understand the questions and provide rational answers. Moreover, the accused cannot benefit from a minor contradiction in the child's testimony, and no corroboration of the child is required when her testimony remains credible and consistent. The bench, comprising Justices J.B. Pardiwala and Manoj Mishra, summarized the law regarding the child witness testimony in the following words: The Evidence Act does not prescribe any minimum age for a witness, and as such, a child witness is a competent witness, and his or her evidence and cannot be rejected outrightly. As per Section 118 of the Evidence Act, before the evidence of the child witness is recorded, a preliminary examination must be conducted by the trial court to ascertain if the child witness is capable of understanding sanctity of giving evidence and the import of the questions that are being put to him. Before the evidence of the child witness is recorded, the trial court must record its opinion and satisfaction that the child witness understands the duty of speaking the truth and must clearly state why he is of such opinion. The questions put to the child in the course of the preliminary examination and the demeanor of the child and their ability to respond to questions coherently and rationally must be recorded by the trial court. The correctness of the opinion formed by the trial court as to why it is satisfied that the child witness was capable of giving evidence may be gone into by the appellate court by either scrutinizing the preliminary examination conducted by the trial court or from the testimony of the child witness or the demeanor of the child during the deposition and cross examination as recorded by the trial court. The testimony of a child witness who is found to be competent to deposit oblique depose, that is capable of understanding the questions put to it and able to give coherent and rational answers, would be admissible in evidence. The trial court must also record the demeanor of the child witness during the course of its deposition and cross examination, and whether the evidence of such child witness in his voluntary expression and not born out of the influence of others. There is no requirement or condition that the evidence of a child witness must be corroborated before it can be considered. A child witness who exhibits the demeanor of any other competent witness and whose evidence inspires confidence can be relied upon without any need for corroboration and can form the sole basis for conviction. If the evidence of the child explains the relevant events of the crime without improvements or embellishments, the same does not require any corroboration whatsoever. Corroboration of the evidence of the child witness may be insisted upon by the courts as measure of caution and prudence where the evidence of the child is found to be either tutored or riddled with material discrepancies or contradictions. There is no hard and fast rule when such corroboration would be desirous or required and would depend upon the peculiar facts and circumstances of each case. Child witnesses are considered as dangerous witnesses as they are pliable and liable to be influenced, easily shaped and molded, and as such the courts must rule out the possibility of tutoring. If the courts, after a careful scrutiny, find that there is neither any tutoring nor any attempt to use the child witness for ulterior purposes by the prosecution, then the courts must rely on the confidence inspiring testimony of such a witness in determining the guilt or innocence of the accused. In the absence of any allegations by the accused in this regard, an inference as to whether the child has been tutored or not can be drawn from the contents of his deposition. The evidence of a child witness is considered tutored if their testimony is shaped or influenced at the instance of someone else or is otherwise fabricated. Where there has been any tutoring of a witness, the same may possibly produce two broad effects in their testimony: improvisation or fabrication.